Welcome back, viewers. Tonight we've been discussing the role of a personal injury lawyer, and we're hoping that this provides information to assist you with any matter regarding personal injury and just the role of a lawyer in general as well.
Thanks,
Tony,
Kathy.
what questions can we answer for viewers?
To recap, we're talking about the role of the lawyer in preparing for the case and a bit of preparing your client and collating information, obtaining medical reports, photographs, attending the scene of an accident, getting engineers involved. We're talking all about that.
Not to mention witnesses, Tony, as well, because they play a major role in a client's case.
Of significance, we need to know everything about a particular client. We need to know their past, their background, if they've been in jail or out of jail, or just everything in general, because people out there, you've got to understand, the lawyers are like your priest. If we don't know everything about you, we can't prepare you for court. Rest assured that before you get to court, the opposition will know everything about you. They'll do police checks. Don't ask me how they get that information, but they do. They'll do police checks. They'll do Facebook checks, Twitter, all sorts of things.
Tony, they'll know more about the client
than the client knows about themselves.
Exactly.
John, we're talking about now in preparing for court, you've got negotiations that are ongoing with the opposition. Is that correct?
Exactly. Look, we need to prove our case. We need to. We've got the onus is on us to discharge the burden of proof here. So we have to persuade WorkCover or the Transport Accident Commission or the defendant that our injury is a solid injury and you're suffering permanent injuries from this, Tony. Mm-hmm. Now, we do that. But John,
assume we've gotten past that process of serious injury, right?
All right.
We're well past that.
Yes.
We've had our conferences, the matter hasn't resolved. Or, sorry, there's negotiations, isn't there?
Mm-hmm.
Okay.
And
there's mediation down the track. What's a mediation?
A mediation is generally an informal forum where you meet to try and compromise and to see if you can reach some sort of resolution. However, it's not binding on the actual court, so if you can't reach resolution, then you can maintain the proceedings that are on foot.
But at the mediation, you've got a mediator, which is generally a barrister with a bit of experience.
Well, generally the barrister will assist in the matter. Each barrister, one for the plaintiff and one for the defendant, and there's a mediator.
Yeah, who's also a barrister.
Oh, that's right.
And the mediator will give indications to both sides as to their strengths and their weaknesses in their case.
That's exactly right. But a lot of that whatever's discussed in the mediation is privileged, which means that it stays there.
It stays there. It can't be used in court.
So it's on a without prejudice basis.
Yeah, it's all without prejudice.
That's right.
Now, the thing is, once you're preparing for court, John, what are you doing? Subpoenaing every man and his dog? What do you do?
First is to prepare the injured party how to give evidence. In what way they should be telling their story to the judge and jury.
Well, basically you're saying listen to the questions and answer them.
Exactly.
Don't go waffling and wandering on and talking about other things.
Absolutely. May I just add on that point that when you're actually in court and a hearing is taking place, it's actually the information that is stated in front, if there's a jury in that matter, or in front of the judge on the day, that it will be taken into account for the merits of the case. So it doesn't matter about what anyone else has been saying outside of the scope. It's what's on paper in a court book, which is the information that we prepare for our client.
And Kathy, importantly, the best answers are generally yes and no, and you don't want to elaborate too much because sometimes you say too much. And
sometimes.
Well, Tony, I tell all my clients, the judge and the jury want to hear from your mouth, your story, how you were injured and how it affects you on a daily basis.
But John, you don't want them to recount what they had for breakfast and what they're going to have for dinner.
But that's generally
you've got to concentrate. You've got to basically answer the questions and don't stray outside of those.
And concentrate to the issues at hand, which are what the injury is and how the injury affects you.
And keep it brief.
Exactly.
Because, I mean, these trials seem to drag out for quite a bit these days. I mean, the case that ran the other day went for 10 days.
First and foremost, be honest and truthful in your answers, as they will come out in terms of credibility.
Oh, yes. That's crucial. If you're not honest and you're not truthful and you don't disclose everything under the sun about your life, you may as well forget it.
Well, John, the important thing about doing what you just said is that if you bring out that you've had past accidents or that you've been to jail or whatever, it eliminates the element of surprise.
Exactly, and you need to tell the lawyer that from the start.
And also surveillance, Kathy. We discussed this in another episode. It's very important that you're consistent.
Absolutely. I mean, you have to be truthful, and whatever you're saying to one person should be, it's not that you should be saying it to the other person, but don't be going outside the scope and don't be saying one thing to one person and something else to another, as it will affect, again, your credibility, because surveillance will be placed on you, and this is where it comes down to and where it's most important.
Tony, I tell all my clients that when you're in the witness box and you're going to give evidence, you have to be ready for every question under the sun.
But just be truthful. Just let it come out naturally. Don't try and think of some,
No, not at all. It has to be...
Don't concoct a story is basically what happens,
right.
because it won't do you any favours and it won't help us either.
And concentrate on the injury at hand. Don't discuss, if it's a neck injury, don't start talking about your toes and fingers and other things.
Exactly.
Isn't that right?
Exactly, yes.
And what happens, you get to court, you've prepared your briefs, court books.
You have court books, you have barristers, usually a Queen's Counsel or a senior counsel, and a junior barrister who will present the case to the judge and jury, Tony.
And there's a whole stack of information, court books. What are they, Kathy?
Well, that's the information that we provide to the other side and to the judge with in preparation of the case. So it's the information that we are relying on, and that we are, well, we're hoping that this is going to form the case, to be honest.
And that entails the court documents, the medical reports of the plaintiff and the defendant, any other documents such as financial documents, tax returns, the expert reports, Tony, very important, the experts, aren't they?
Oh, without fail.
But can I make it a little bit more general? I think sometimes our clients don't really understand what we do on a day-to-day basis as well. I mean, it's not just the preparation of a brief when we're going to a hearing. We do a lot of other work in between on a casual stance.
Yeah, you're chasing freedom of information documents.
Not just that, we make appearances in court in front of a magistrate or in front of a judge to actually take direction.
Hearing.
That's right, to take direction of how the matter's going to progress. We look at all the information on hand to see whether the client needs anything further, or whether there's any names that we don't know what is listed. So we have to ask questions, whether there's any more injuries that we need to be aware of. So there's a lot more than just letters and picking up the phone that we do.
Just on an issue of communication, John, what's the best approach? I
communicate with all my clients.
But what's the best approach? I prefer them to send me an email or a facsimile.
Exactly.
Setting out what their concern is.
Everyone telephones their lawyer, and yes, that's fine. But of course, if I'm in court all day, I can't literally answer everyone's call.
And that creates a lot of angst. If a client can't get a hold of you, then they start ringing me, and that creates a lot of other problems.
That's what we try to avoid.
Exactly.
So it's important that they send you useful information. Even if they can't speak proper English, just put it as simple as you can. Fax it or email it in.
And your lawyer should always acknowledge that as well, because we understand that the plaintiff or the client in this matter is always wanting to know what's going on with their case, and they have a right to know.
A lot of what I do with clients is before and after, so I generally try and do it with them before hours or after hours. So anyway, look, it's an area of practice that we could talk forever, but viewers, we'll come back to it another time. We're going to the mailbag after the sponsors break, so please don't go away, and we'll be back shortly. Thank you.